Hey everybody, this is Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk about what happens if your estate plan burns up in a fire. Before we get there though, if you have estate planning needs, if you have estate planning questions that aren't answered today, and you want to ask more, please go to estatemeeting.com. You can set up a time to talk with me for free, over the phone or in person, estatemeeting.com. All right, the reason for today's topic is that it was a question from a client. The client called and basically said, hey, what happens if our estate planning documents are burned up in the fire? And I thought it would be nice to come here and tell you what would happen. There are really two scenarios in this fire scenario. Scenario number one is the fire burns up all of the documents and you are not in the fire. If that happens, the solution is quite simple. For your trust or for anything like that, we would likely not do anything. Copies of the trust will work, copies of your power of attorney will work, copies of your medical power of attorney will work. What we really need to keep the original of is the will. So if your will burned up in a fire, we would likely just have you come in and sign a new will. It's that simple. Everything else still works. The copies still work, and we'll make you a new original of the will because it makes things easier when you're gone. If you are unfortunately, sadly, tragically burned up in the fire too, or you die in the fire as well, and by the way, I'm not trying to make light of this. It's just, you can smile through it or we can be sad through it. But if you also died along with your estate plan in the fire, it is possible to use copies of your will. There are just a few extra steps that you have to go through to allow the court to accept the will as your own. Basically, the court just wants to make sure that if the original does not exist, that you did not intentionally revoke it and intentionally destroy it. The way that you revoke a will traditionally is to literally destroy it, tear it in half, burn it up. There's sort of I'm reminded of, this is by the way, not even close to a great example, but I'm just gonna tell you what popped into my mind there's this episode of The Office where Michael Scott thinks that the business is going to go under, and he starts walking around going, I declare bankruptcy. And that is sort of what has to happen with your will. If you actually want to revoke it, you need to not just say it, but you have to actually undergo an affirmative act, which is literally destroying, tearing up, burning the will. So as long as you can demonstrate to the court that was not the case, which when the scenario that we're talking about would be relatively easy, as you died in the fire as well, the court would accept the copy of the will as the original, and you could go on as planned. All right, so that's sort of the answer. That's it. If you have any other specific questions about this, you can leave a comment below. If you like this video, please like it. If you know someone that needs to hear it, please share it. And like I said before, if you or someone you know needs estate planning help, please don't hesitate to reach out. Go to estatemeeting.com. You can set up a time to talk over the phone or in person for free, and it will be great. Guarantee you will walk away with more knowledge about estate planning, about what your estate plan should look like, and you'll be able to make an informed decision. All right, I am Christopher Small. I'm the owner of CMS Law Firm. Thank you so much for your time, and I will probably talk to you again tomorrow.